Good afternoon, everyone, and welcome to today's webinar hosted by the Chesapeake chapter of the Association of Proposal Management Professionals. My name is Steve Bacon. I'm a government contracts attorney with the law firm Rogers Joseph O'Donnell. I'm going to be presenting the Bid Protest Playbook, a guide to federal procurement challenges. As proposal professionals, there is a very real possibility that your work will come into contact with the bid protest system at some point. That is true whether your proposal is on the winning side or the losing side of a procurement. So it is important to have at least a basic understanding of the bid protest system, how it works, and what you need to consider if you are thinking about filing a protest. Imagine that you just received notice that your company lost a bid and you think something went wrong with the agency's evaluation. My goal today is to give you a playbook you can use to decide what to do next. I'm going to present for the first 45 minutes or so of the webinar, and we will leave the remainder of our time for questions. Please jot down any questions you have as we go, and I'll be glad to answer them at the end of our program. We'll start the webinar by talking about some of the bid protest fundamentals, like where a protest can be filed and the timeliness rules that apply to bid protests. Then we'll talk about bid protest strategy and decision making. I want to start our discussion by providing an overview of different types of bid protests that can be filed. Now, this is not an exhaustive list here, but this table includes some of the more common bid protest grounds that come up. As you'll see, I've organized the table by pre-award protests and post-award protests. I think it's critically important to keep in mind that there is a fundamental distinction between a pre-award protest and a post-award protest. A pre-award protest is a challenge to the ground rules of the procurement. So when you file a pre-award protest, it's because you've identified some flaw or defect in the solicitation. This is different from a post-award protest, where you are challenging how the agency evaluated proposals and applied the solicitation criteria. You need to keep this distinction in mind because, as we'll discuss later, this has very important implications for when the protest must be filed. In general, a pre-award protest must be filed prior to the deadline for proposals, while a post-award protest is filed after the award is announced. Post-award protests are much more common than pre-award protests. In my view, pre-award protests are an underutilized tool, and I think especially important for proposal professionals to be familiar with. As I said before, the goal of a pre-award protest is to fix a problem with the solicitation itself that will allow you to compete more effectively. And this is illustrated by a few of the example pre-award protest grounds that are listed here. You have unduly restrictive requirements, for example, which is a common pre-award bid protest ground. This is where there is some requirement in the solicitation that is preventing you from competing. In general, agencies have broad discretion to define their requirements, but there are some instances where you can show that there is no reasonable basis for the agency's requirement, and you may file a protest to try to get the requirement removed from the solicitation. You can also protest a solicitation that contains ambiguous or conflicting terms. In fact, you have a legal duty to clarify terms that are ambiguous. The rule here is, if you see something, say something. So when you review a solicitation, if something is obviously wrong, you can't just ignore it. The law requires you to try to clarify it, and if the agency doesn't clarify it through an amendment, then you need to file a timely pre-award bid protest. The pre-award stage is also a time to challenge any illegal terms included in the solicitation. So, for example, FAR Part 12 prohibits the use of terms in commercial item contracts that are not consistent with customary commercial practices. If you spot one of those in a commercial item solicitation, you could challenge that in a pre-award protest to try to remove the illegal term. Similarly, you might challenge a solicitation because it fails to include a mandatory term that's required by law, like the Service Contract Act clauses or Davis-Bacon Act clauses that are mandatory. You may also challenge the evaluation method used in the solicitation if it could produce misleading or unfair results. This comes up sometimes in the method chosen by the agency to evaluate price. Okay, so those are some of the common pre-award grounds. I want to talk next about post-award grounds, which you see here on the right-hand column of the table. First one here, deviation from the solicitation, is a classic post-award challenge. So you learn that the agency has evaluated your proposal in some way that is inconsistent with the criteria announced in the solicitation. I put this one first because it's probably the most compelling ground that will get traction in a post-award bid protest. GAO and the court are reluctant to second-guess the agency's evaluation, but they are more inclined to sustain a protest if you can show that the solicitation said X, but the agency did Y when it came to the evaluation. You can also challenge whether the agency reasonably evaluated proposals. So on the technical factors or past performance, for example, you might be able to argue that the agency's evaluation conclusion was just not reasonable. On cost or price, you may be able to attack the agency's evaluation of cost or price realism or the evaluation of cost reasonableness. Again, as I said, the agencies are generally afforded discretion in their evaluation conclusions, so you really have to show that there is a pretty substantial flaw in the agency's logic to win this kind of protest. Another post-award ground is improper discussions. In some negotiated procurements, the agency will conduct discussions with offerors. You can challenge the conduct of those discussions as being either unequal or not meaningful. That is a protest ground that gets raised quite often. And also, in a best value procurement, it is common for protesters to assert that the agency's best value determination was flawed. A common argument here is that the agency did not adequately justify paying a price premium to a higher price proposal. If this has merit, it's often because the agency didn't adequately document the trade-off analysis in its source selection decision, which comes up quite a bit in bid protests. So down here at the bottom of the table, I put 3 grounds that sort of sit in a gray area because they can be pre-award or post-award grounds depending on the circumstances. These are OCI and bias grounds, Procurement Integrity Act violations, and challenges to improper sole source contracts. I won't cover these in detail, but you should be aware that special timing rules may apply to these unique protest grounds. So that covers some of the common grounds, just to give you a flavor of the types of protest issues that get raised. As I said before, this is not an all-inclusive list, but it does give you a sense of the kinds of issues that come up in a bid protest. I want to move next to discuss the different bid protest forums, so you have an understanding of where a protest may be filed. So these are the 3 main forums here: agency level protests, a GAO protest, and a protest filed at the Court of Federal Claims. With some exceptions that we'll talk about later, all of the protests we discussed in the last slide can be protested in any of these forums. So from left to right, we start with agency level bid protests. This is the most informal type of protest you can file with the contracting officer. It encompasses any written objection or statement of dissatisfaction with the agency's actions and requests some form of relief. Agency level protests are supposed to be decided within 35 days, which is relatively quick. However, the principal downside of an agency protest is that you are not entitled to documents and there is no protective order. So the information available to the protester is very limited. The protest is also decided by the contracting officer, who, of course, is the very same person that was likely responsible for whatever action you are challenging. So for those reasons, agency level protests are usually not an attractive option, particularly in a post-award protest where you really do need to see the evaluation documents to be able to substantiate your claims. Agency protests are often best utilized in the pre-award stage, where you want to urge some kind of change to the solicitation. An agency level protest gives you a mechanism to have a conversation with the agency in the form of a letter exchange to the contracting officer without all the attention of a GAO or Court of Federal Claims protest. So agency level protests are a plausible option sometimes for a pre-award protest where you think you might be able to persuade a contracting officer to make whatever changes you'd like to see in the solicitation. The most popular form by far is GAO. GAO is relatively quick and efficient at adjudicating bid protests. They are required by statute to resolve protests within 100 days, and they almost always meet that deadline. A key advantage of filing a GAO protest is that it triggers an automatic CICA stay on the contract. CICA is the Competition and Contracting Act, where the CICA stay came from. The stay means that the agency can't move forward with the award or performance until the protest is resolved. As a protester, that's very important because it preserves the status quo so that if you win the protest, there's still actually a contract left to perform. At GAO, the protester is entitled to documents that are relevant to the protest grounds raised. So if you challenge an agency's evaluation of the awardee on factors 1 and 3, you won't get the documents for the evaluation with respect to factor 2. And that limitation has important implications for your protest strategy that we'll discuss later on. The other unique thing to note about GAO is that they make recommendations to agencies when they sustain a protest. In almost all cases, agencies follow those recommendations. However, they are not legally required to, and in rare cases, they don't. I know they do have to notify Congress in any cases where they don't follow GAO's recommendation. So it is a rare occurrence. The Court of Federal Claims is different in that it can order injunctive relief in a bid protest to stop a contract from moving forward. The bid protests at the court are randomly assigned to a single judge who decides the case. And there's no statutory timeline for resolving protests like there is at GAO. The court may resolve the protests within 3 or 4 months. So they try to move things along fairly quickly at the court, but the timeline does vary from case to case, depending on the size and complexity of the issues, the judge that's assigned, among other issues. DOJ, the Department of Justice, represents the agency at the court, which is different from GAO. At GAO, the agency is represented by agency attorneys within the agency involved in the procurement. So the court operates much like a federal district court would, and the same rules of procedure generally apply. Notably, at the court, the agency must produce a complete administrative record for the procurement, which is different from GAO. As I mentioned before, at GAO, the record is limited by the scope of the allegations raised. But at the court, the protester gets a complete record, so you get a much more visibility into the documents underlying the evaluation when you file a protest at the court. And this is a significant factor that may sometimes counsel in favor of filing a protest in court. But as we'll discuss on the next slide, you can, in most cases, you can file your protest at GAO and then go to the court if you don't like the decision that you get from GAO. So this slide is showing the different paths a bid protest can take. So if you want in option 1, you can go from an agency level protest to a GAO protest to a protest at the Court of Federal Claims. And if you don't like that decision from the Court of Federal Claims, you can appeal it to the Court of Appeals for the Federal Circuit. And in fact, if you don't like the decision from the Federal Circuit, you can try to appeal the issue to the U.S. Supreme Court. They very rarely accept government contracts cases. So as a practical matter, the Federal Circuit is the court of last resort, in any bid protest or in most bid protests. In option 2, you can skip the agency level protest and file at GAO, and then take a second bite at the apple at the Court of Federal Claims if you don't like the decision from GAO, and you can appeal to the Federal Circuit. And the last path, option 3, is to go directly to the Court of Federal Claims to file the initial protest. So you can skip GAO and the agency level protest altogether and file your bid protest complaint directly in court. All of these are available options in most cases, and I would say option 2 is the most common path and the path that makes the most sense, particularly for post-award protests. That gives you the seek a stay that you get when you file a GAO protest, and then you can see what result you get there. And if it's an adverse decision at GAO and you think they got it wrong, you can get another shot by filing your protest in court. There's one significant exception to that for task and delivery order procurements under FAR Part 16.5. So this is for orders placed under a multiple award IDIQ contract and awarded using fair opportunity procedures. GAO has exclusive jurisdiction to decide protests in connection with task and delivery orders, and only if the order exceeds certain statutory thresholds. So for DoD, NASA, and the Coast Guard, it's $25 million, and for civilian agencies, it's $10 million. So that's a significant limitation on the court's bid protest jurisdiction. They do not have jurisdiction to hear protests in connection with task and delivery order. When we talk about bid protest timing, we have to go back to the distinction between pre-award and post-award protests. If you have any objection to the terms of the solicitation, you have to file your protest prior to the deadline set for receipt of proposals. That rule is the same for agency level protests, GAO protests, and protests filed at the Court of Federal Claims. The post-award rules are a bit different depending on the forums. At the agency level, you have to file within 10 days of when you knew or should have known of the basis for protest. At GAO, you have the same 10-day clock, but there's an exception for requested and required debriefings. If the debriefing exception applies, the 10-day clock does not start until the debriefing is closed. The exception only applies if there was a requested and required debriefing. So this means that the debriefing was timely requested within 3 days of award and required by law or regulation. Debriefings are required in FAR Part 15 procurements and task and delivery order procurements under FAR 16.5. Importantly, though, a brief explanation of award in a GSA scheduled procurement under FAR 8.4 is not a required debriefing. So you have to know what part of the FAR you're in so you can be sure that the debriefing exception applies at GAO. At the court, the timeliness rules aren't as strict for post-award protests, but if you wait too long to file in court, it can impact the judge's view as to whether you should receive injunctive relief. So you always want to act quickly to make sure you preserve your rights. So if things weren't complicated enough with bid protest timing, there are actually separate timeliness rules for triggering a seek a stay. A seek a stay is triggered if your GAO protest is filed prior to award. In that case, the agency can make an award until the protest can't make an award until the protest is resolved. If the award has been made, though, a stay of performance is triggered if the GAO protest is filed within 10 days of award or 5 days after the debriefing date offered, whichever is later. So if the agency offers a debriefing date, you should take it to make sure that you're able to take advantage of that rule, giving you 5 days after the debriefing date offered, which is often after or longer than 10 days after award. So this next slide just shows a sample bid protest calendar so you can see how these timelines work in practice. So suppose you get a notice of award today, May 1st, and you make your timely debriefing request the next day, and the agency holds the debriefing on May 10th. At that point, you're 10 days after award, and so you have a 5-day clock to get your protest on file at GAO if you want to trigger the SICA stay. So you'd be targeting May 15th as your deadline to file an initial protest to make sure you trigger that SICA stay. Now, putting aside the SICA stay, your protest would be timely under GAO's rules if it's filed within 10 days of the close of the debriefing. So you'd actually have until May 20th to file a timely GAO protest. So what you can do is you can file the initial protest on the 15th to trigger the SICA stay, and then file a supplemental protest on May 20th with any additional grounds that you might have. And that second supplemental protest on May 20th would be timely under GAO's rules. Bid protest standing and prejudice are the last two fundamental concepts I want to talk about before we get into strategy. These are related concepts that you need to be aware of because you have to satisfy both in order to succeed in any bid protest. To establish standing, you have to be an actual or prospective offeror that has a direct economic interest in the procurement. There are a number of different considerations that can be relevant to the standing analysis. In general, if you're not an eligible offeror, you don't have standing to protest. So suppose a contract is set aside for women-owned small businesses. A company that is not a woman-owned small business would not have standing to protest that contract because they're simply not eligible to compete. Standing can also impact whether GAO or the court will reach the merits of your protest allegations. So suppose you're deemed technically unacceptable on one of the evaluation factors, and you challenge that finding in your protest, but you also argue that there were additional errors under some of the other evaluation factors. Well, if GAO finds that the agency correctly found that your proposal was unacceptable, then you would not have standing to challenge any other aspects of the agency's evaluation. So GAO and the court are going to look first at whether the agency was right that your proposal was unacceptable. And if that's the case, they're just not going to decide the merits of any of the other protest grounds that are raised. In addition to standing, a protester also has to establish that it was competitively prejudiced by the agency's errors. The protester has to show that, but for the agency's errors, the protester would have a, quote, substantial chance for award. So suppose you are able to show that the agency incorrectly assigned a weakness to your proposal, but the awardee had 7 strengths and a lower price. In that situation, GAO may say, well, yes, the agency should not have assigned a weakness to your proposal, but even without the weakness, you would not have a substantial chance for award because the awardee is just so much more superior given all the other strengths. And so we're not going to sustain your protest because you haven't established competitive prejudice. So you have to get over the standing hurdle at the outset of a protest and then the competitive prejudice hurdle when you prove that the agency made some error in the procurement. And that error has to be prejudicial error in the sense that there is a reasonable possibility that it may have changed the outcome of the agency's source selection decision. So I want to transition now to talking about bid protest strategy and the things you should consider when deciding whether to protest. In the pre-award phase, your core objective is to position yourself for success. That has to start with a prompt and careful review of the solicitation so that you can identify problems that might need to be addressed in a pre-award protest. The good news is that this is already part of your jobs as someone that writes proposals. You're already meticulously reviewing the solicitation and trying to spot issues. And so when you do this, it's important to keep the possibility of a pre-award bid protest in mind. Recall what we discussed earlier about the timing of pre-award protests. The law requires you to come forward to challenge any defect in the solicitation prior to the proposal deadline. If you see something, say something. That's the rule. So there are a few key questions you should be asking yourself as you're taking a look through the solicitation. Are there requirements that you cannot meet? If there are, you might as well no bid the opportunity. So if you identify a requirement that you can't meet, you have to consider if there's some basis to challenge it. You also need to ask yourself if there are any defects or ambiguities in the solicitation that need to be clarified. These issues need to get fleshed out in the Q&A process. However, if the agency doesn't clarify, you should be prepared to protest to resolve the ambiguity. You should also think about whether there are any changes to the solicitation that might eliminate your competitors or weaken their position. And if there's a way you can raise a pre-award protest to try to make that happen, that's also something that you want to think about. And lastly, you want to identify any structural problems with the RFP that need to be fixed. One example of that might be a situation where the RFP is unclear about the type of contract that will be used. You would want to seriously consider raising that issue in a protest so you don't enter into a contract that you just don't fundamentally understand. So I want to talk now about preparing for a post-award protest during the pre-award phase. I think it's important for contractors to begin doing this before an award is announced, particularly for significant procurements where there is a high likelihood of protest. As we saw earlier, the bid protest timelines are very tight. Your chances of putting together a viable protest are much better if you're able to do some legwork during the pre-award stage to make sure that you're ready. So hope for the best, but plan for the worst. So how do you do this? I think you need to start by identifying your core strengths and unique advantages on each evaluation factor. You want to arm yourself with arguments that you should have been rated higher technically than any of your likely competitors on each factor. Now, this might not be realistic in every case to identify these unique advantages, but it's something you should think about to try to be ready for a protest. You also want to think about how you can directly attack your competitors. Now, that involves collecting market research on your competitors, which you are likely already doing to some extent for the proposal. So I've listed some examples here of things that can be useful in a protest, like data from the Federal Procurement Data System. This provides information on your competitors' prior contracts that you may want to use to challenge their past performance or experience. You can also look at your competitors' websites and any publicly available information about their products that you may be able to use to show that their solution is not compliant with the terms of the solicitation. LinkedIn. This is a big one. It's being used regularly now in bid protests to raise allegations about key personnel in particular. You also want to consider the business intelligence that you're gathering and picking up along the way as you compete for different procurements. So you're thinking about who they're teaming with, and all of that could be fodder for bid protests, raising issues like organizational conflicts of interest and things like that may be implicated by your competitors' work on other contracts. Also, SAM registration. This has been a hot topic recently. There's been several bid protests that have resulted in proposals being disqualified for having a lapse in their SAM registration. So that's something that's publicly available. You can go see when another company was registered in SAM, and if there's a lapse in their registration, that may be grounds for a protest. There's also small business size and affiliation issues that can be raised. And this is not something that we've focused on specifically today, but that's an entirely separate avenue of protest that you should consider if you're competing for a set-aside contract. Those protests are filed with the SBA, the Small Business Administration, and they can be a powerful tool to eliminate a competitor that shouldn't qualify as a small business. So hopefully you are at least somewhat prepared for the possibility of a protest by the time an award is announced. But the real foundation for any protest starts with the information provided in the debriefing. Unfortunately, there is a lot of variability in what you get in a debriefing. FAR 15506D lists out the minimum information you're supposed to receive. It includes your significant weaknesses or deficiencies, the price and rating of the awardees, a ranking of offerors if the agency did one, and a summary rationale for award. This is the minimum information that you should get, and you want to make sure that you get at least this by timely requesting a debriefing after the award is announced. You're supposed to also get reasonable responses to relevant questions, but anyone who has been through this process knows that the agency is usually very circumspect in its responses. So you should take advantage of the opportunity to ask questions and get what you can, but don't expect that the agency is going to give you a whole lot here that will be useful in a protest. But it's still worth it to ask questions and see what additional information you can get. Industry frustration with the debriefing process was one of the factors that led to the requirement for DoD to implement enhanced debriefing procedures, which are now codified under the DFARS. And these procedures allow for follow-up questions after the initial debriefing. And you also get a redacted source selection decision document in some circumstances where the contract exceeds certain thresholds. The redacted SSDD can be particularly helpful in giving you an understanding of the significant factors that led to award. And lastly here, again, another reminder that you're not entitled to a debriefing under a FAR 8.4 GSA schedule procurement. You're only entitled to a brief explanation, which can be a very bare bones explanation and give you very little in terms of information about how the award was made. So many times in a GSA schedule procurement, you have to protest just to find out more about how the award was made and what ratings the offerors received, which is unfortunate. So once you get your debriefing, it becomes crunch time for deciding whether to protest. You need to be able to rapidly assess the situation and make this informed decision within a very short period of time. And I think there are a few key questions to consider. Do you have a viable protest? So here you're trying to determine if you have a credible, factual, and legal basis to allege that there was some flaw in the agency's process. This should be done on a factor-by-factor basis, considering all of the information and the evaluation factors in Section M of the solicitation. Now, this doesn't necessarily mean that you protest on every factor, but each one should be considered. As I mentioned earlier, the record at GAO is limited to the documents that are relevant to the protest grounds alleged. So you want to try to maximize the surface area of your protest by considering protest grounds on all of the evaluation factors, which is going to expand the size of the record that you get at GAO. That is a very important consideration in developing your protest strategy. In addition to the factor by factor analysis, you want to think about whether some of these other protest grounds may be viable, like discussions, either improper discussions, unequal discussions, or not meaningful discussions, attacking some aspect of the price evaluation, raising OCI or bias issues, and looking for ways to attack the agency's ultimate best value determination. In addition to considering whether the protest is viable, you also want to consider if there's a realistic path to success, or if this is just going to result in a Pyrrhic victory. There's a better path to success if you have a credible argument that the awardee should be deemed ineligible. So if you have that kind of protest that you think you can make, that is one that really does have a decent chance of resulting in you being ultimately awarded the contract, assuming that you were competitive and at least close in terms of ratings to the awardee that you're challenging. Now, if you can't knock out the awardee in a protest, then you want to think through your chances of success in a hypothetical corrective action scenario. So you might think about, in a best value procurement, can you get to a point, if your protest grounds are sustained, where the best value trade-off calculus may be different for the agency? Or even if you prevail in the protest, is this going to be, as I said before, a Pyrrhic victory? So you want to think through that before you protest to make sure that that protesting is the right decision and will give you some realistic possibility of ultimately winning the contract if that's your objective. One of the things that makes the go, no-go decision difficult is that you're operating on incomplete information. You're not sure what the evaluation record may ultimately show. You don't have access to that typically prior to filing the protest, although through the DoD enhanced debriefing procedures, sometimes you get a little bit more there with the source selection decision document. But once you file the protest, your attorney who gets under the protective order will have the opportunity to learn much more about what happened and be able to review the underlying evaluation documents. And it's very common that once that happens in a protest, that supplemental protests are filed based on the new information that the protest attorneys learn in the evaluation record. And these supplemental grounds are often more credible than the initial protest grounds because they're based on what actually happened and what the parties and the protester's attorney is able to see in the evaluation record. So the X factor is that whenever you file a protest, there's some possibility that you'll find a supplemental ground that, if it's not a smoking gun, maybe it changes the outcome, and that's often the case in protests that get sustained. The supplemental protests are often the ones that result in a sustained result at GAO. There may be other considerations that motivate companies to file a protest. For example, as an incumbent contractor, a protest that triggers a SECA stay may extend the duration of your incumbent contract, and that may create a greater incentive for you to protest if it allows you to keep your ongoing work for a period of time. So that's something that's a consideration. You may also want to consider how filing a protest would impact your relationship with the agency and your prospects for future business with the agency. Some contractors fear that filing a protest will damage them in the eyes of the agency, and hamper their ability to win contracts in the future. Personally, I think that fear is somewhat overblown, but nonetheless, it is something that certainly should be considered before filing a protest. So that concludes the content portion of the webinar. I'd be glad to take any questions you all have for me in the next segment. Also, if anyone would like to contact me, please reach out. My email is sbacon@rjo.com. Thank you all for attending today, and I look forward to your questions.